My name is Paul Magrath and I'm here to talk to Lucy Reed about transparency in the family justice system. Lucy, what do we mean by transparency in the context of family law?
I think that people treat transparency as being all about abandoning privacy, publishing judgments, sitting in open court. But actually transparency is something rather different to that. It's about making family justice and the way it's done accessible and understandable to people. So we can publish judgments that might be going some way towards the objective of making proceedings transparent, but in itself it doesn't achieve transparency, because if people and the wider public don't find judgments on bailey or don't read them or aren't able to understand them, then we haven't achieved transparency.
How does transparency impact on parties and professionals in family law cases?
Well, I think that it's often very anxiety-inducing, both for professionals and for the parties who are involved in the case. But that's because it's unfamiliar and we're not used to managing the attendance of journalists very often, or more novel setups whereby perhaps judges sit in open court, or there is more distribution or access to documents. But it need not be anxiety-inducing, because we all as professionals need to get better at dealing with the practicalities, at reassuring parties and indeed professionals that finding ways to make proceedings more accessible doesn't need to mean that we completely abandon privacy, respect for people's intimate personal affairs, etc.
What are the benefits of transparency?
I suppose there are two main areas of benefit. One is that greater transparency will help the public to understand what we're doing and why we're doing it, and that hopefully will improve confidence in the system, or if it doesn't improve confidence, would drive reform so that the system works better. But also I think there are potential benefits to the people that work in the system, the professionals who are involved. If we operate in a sort of hermetically sealed environment, there's a danger that we will continue doing things the way that we've always done them, because that's the way we've always done them. And I think it's helpful perhaps sometimes to hear the perspective of people who are looking in from the outside, who might say, why are you doing things this way? And actually having those sorts of constructive questions from people who understand, because they can see it, how the system is working, has the potential to help us think of new and better ways to do things.
What further developments can we expect in transparency in the coming months?
Well, there have been a number of things that have happened since 2014. Firstly, the President of the Family Division produced guidance in relation to publication of judgments, which applied both to the Family Court and the Court of Protection. That has been implemented, but research tells us that that's been somewhat patchy. Following the implementation of that guidance, the President issued later in 2014 Next Steps consultation, and that really was proposing various steps to improve the information that was provided to journalists to really facilitate more and better reporting. So, for example, giving them better listing information so they can decide whether to come to court, and then if they're at court, perhaps giving them access to documents so that they can understand and report better. That consultation produced very polarised responses, and it hasn't led directly to anything. Alongside those reforms, the Court of Protection has been running quite a long-running pilot, which has now been formalised in the rules, which effectively means that many cases are dealt with in open court with reporting restrictions, so there is much greater access to those proceedings. That hasn't translated into the Family Court, and there aren't any specific proposals for that to happen. But we do know that since the Next Steps consultation, the President of the Family Division has repeatedly said he does intend to produce a further consultation around the area of transparency in the family courts. We haven't had that yet, and we may get it soon. But recently there has been a small further development in that the President has issued his 18th view, and that indicates an intention that in the new financial remedies specialist courts, judges will be reporting their judgments in small and medium-sized cases. We don't know exactly how that's going to work in practice, but certainly that's a clear reform that the President has indicated will happen.